This module deals with the law and its impact on natural resources and the environment. Along with economics, ethics, these systems have a profound impact on the management and sustainability of natural resources. The topics for today are really threefold. We're going to talk a little bit about the functions of law, how it works to deal with allocation of resources, the sources of law, and different patterns of law that exist in natural resources and environmental management. So the functions of law in the context of natural resources or in the environment are predominantly these six. So one of the functions is to allocate resources. We live in an imperfect world. If there were plenty of resources for everyone and everyone had all the resources, all the environment they desired, we wouldn't need to allocate because everyone would get what they want. We don't live in a perfect environment. And so the law and economics and ethics and the political system are critical in allocating resources. We talk about allocation, we talk about ownership of resources, who's entitled to the resource, how much they're entitled to, how long, and can they exclude others. So that's a critical function of law. A second function of law in the context of natural resources is protecting human health. At what level of health should we be protected? What probabilities of injury? So in addition to protecting the environment, resource law also deals with protecting human health. The third area is resource protection. The critical questions are at what level and how long do we protect these resources? For example, the Wilderness Act, the Federal Wilderness Act, really doesn't put a time frame on the ending period for protection of wilderness. It could go on for multiple generations. So in terms of resource protection, the law speaks to these issues of what level of protection and length of time. Another function of law is market failures. Market failures reflect any time we use a natural resource, whoever purchases that resource or services from it ought to pay the true cost. Oftentimes, users do not pay the full cost. And so the function of law in this area is really to internalize or incorporate those pollution costs in the price of the product. A fifth function is to resolve disputes. Again, we live in an imperfect world. There are disputes over how resources are allocated, how resources are protected, the level of protection. And so one of the functions of law is to resolve disputes over who gets what. And the last category deals with environmental justice, where the pollution impacts fall. Do they fall predominantly on poor communities, on developing communities? And one function of the law, at least in the United States and international law, is to deal with these notions of environmental justice. So, sources of law. There are 5 sources that are important to natural resources. Constitutional provisions, statutes and ordinances, administrative rules, executive orders, and judicial decisions. These are sources of law that impact natural resources. Let me talk for a moment about constitutional sources. At the federal level, there are a number of provisions of the Constitution that have an impact on natural resources and natural resource management. The Treaty Clause is a significant part of the Constitution that basically provides in dealing with foreign sovereigns, nations, Indian tribes, only the federal government may negotiate treaties. So if we think about the types of treaties that we deal with in natural resources, we deal with shared resources, we deal with migratory resources, and we deal with common pool resources. An example of a shared resource with respect to the United States is the Rio Grande or the Colorado River. We share these transboundary rivers with Mexico. Correspondingly, in the Great Lakes, we share a number of tributary streams that feed into the Great Lakes with Canada. The way these resources, the way water is allocated and managed, and levels of protection are a function of treaties negotiated between the United States and that foreign sovereign. As we sit here today in 2018, there's extensive discussion on the North America Free Trade Act that deals with goods and services between three sovereigns. Texas may want to negotiate with Mexico over treaties. It does not have the legal authority to do that. It's only the federal government. Migratory resources, classic examples of that are migratory wildlife. The United States and Canada have treaties to regulate the taking, the allocation of migratory resources. How many species can be taken? How can they be hunted? Method and manner of hunting. All these are subject to provisions of a treaty. For example, in hunting, a great dispute for migratory waterfowl was the types of ammunition that could be used by hunters. Initially, hunters used lead. Over time, scientists discovered that lead was toxic to animals that were feeding on the bottom. They were ingesting lead pellets. And so, under provisions of the treaty, the U.S. Fish and Wildlife Service enacted steel shot regulations. The state of Texas and hunters in this state challenged that. Their challenge was dismissed because that was a treaty provision subject only to the regulations of the federal government. A third category are common pool resources. These are resources in which no sovereign asserts jurisdiction and ownership. Typically, these exist in the area of fishes and amphibians in the oceans. So if you think about tuna and tuna fish, no one really owns the tuna until they come within the asserted territorial jurisdiction of a federal sovereign. So tuna regulations, the law of the sea, treaties dealing with whales and how whales can be harvested are all subject to treaties between the United States and other foreign nations. A second constitutional source that has tremendous impact for natural resources is the Commerce Clause. The Commerce Clause provides simply that only Congress can regulate commerce among and between the states. And so if we deal with air pollution, Congress has enacted the Clean Air Act as a representation of the authority under the Commerce Clause to regulate a resource, to protect air quality, also to protect human health. Those are functions of law. In terms of water, the Clean Water Act, and the discussion today of waters of the United States. What constitutes those waters? Those are items of discussion that fall within the Commerce Clause jurisdiction of Congress. Toxic chemicals, the Toxic Substance Control Act, or solid waste. Any article of commerce, any natural resource that crosses boundaries is subject to potential regulation and control by Congress. Third category is the Property Clause. The Property Clause basically provides that for lands and water resources, forest, areas owned by the federal government, Congress can pass appropriate rules for the management of those areas. So examples include national parks, U.S. Fish and Wildlife, refuges, forest, monuments, all national forts, Air Force bases, the conversion of Air Force bases to local governments, all of those fall within the jurisdiction of Congress. There's another provision that's impactful and important to the allocation and management of resources, and that's the power of eminent domain. Eminent domain refers to the inherent power of the federal government of states to acquire private property to be used for public purposes, provided there's payment of just compensation. If there's a willing buyer and seller, the land is transferred to the federal government to a state government, to a local government, to a local governmental entity. If the landowner is unwilling, then a process called condemnation is used. And condemnation requires three things. The land or the resource be required for public purpose, the landowner be afforded due process, and the landowner receives just compensation. A case that I was involved with very early in my career taught me a very valuable lesson about the power of condemnation. It involved a city seeking to acquire land to expand its wastewater treatment plant. The property owners were unwilling to sell, and so the city instituted condemnation proceedings. The court agreed that the land was required for a public purpose. The landowner was afforded due process and compensated, but the landowner did not want to vacate the property. And so the sheriff had to physically remove the landowner so that the wastewater treatment plant could be built. This taught me the awesome power of condemnation. The last clause of the Constitution that has an impact is the Supremacy Clause. Anytime Congress speaks to totally manage an area, if it runs afoul of a state law, federal law is supreme. So state statutes will fall if they conflict with a federal provision. At the state level, the patterns vary from state to state in terms of constitutional provisions. One power that is very important at the state level is the police power. The police power is the inherent power of the sovereign, the state, to manage resources, to enact laws, to protect human health, safety, and welfare. Those are three critical elements. If it's protecting public health, public safety, or public welfare, the state, any state then operating under police power can enact laws dealing with the regulation and management of natural resources. States also have the power of eminent domain. A number of states have powers of initiative and referendum. This is a provision that's a powerful tool for citizens to enact legislation that their legislative body refuses to act. Let me give you an example. In the state of Michigan during the 1970s, there were efforts to enact bottle deposit legislation. So if you bought a beverage container in a bottle or a can, proponents wanted a 10-cent deposit to be placed in that to encourage people to return that bottle or can for recycling. The bottle bills, when they were introduced, they stayed, no pun intended, bottled up in legislative committees. And so environmental groups in Michigan, hunting organizations, fishing angler organizations collected the requisite number of signatures, that's called the power of initiative, to put that question on the ballot, and ultimately the voters approved it. This initiative and referendum has taken form in many states through the power of constitutional rights to hunt and fish, constitutional rights to farm. So these are provisions through initiative or referendum that are put to the voters to enact legislation when state legislatures won't act. In Texas, there's a provision in our Constitution, it's Article 1659, that provides that natural resources of the state of Texas are important, and the legislature has the power to enact laws regulating and allocating those resources to protect health, safety, and welfare. Let me talk now for a moment about federal and state statutory laws and examples. So at the federal level, operating under predominantly the Commerce Clause, Congress has enacted the Clean Water Act that deals with protection of water quality for human health and environmental purposes. The Clean Air Act is another example where the federal government has taken over exclusive jurisdiction to promulgate rules protecting air quality. The Resource Conservation Recovery Act, you see it as RCRA, deals with solid waste and solid waste management. It's shared governance between the federal government and the states in managing toxic and solid waste. The National Environmental Policy Act, enacted during the 60s, provides that for any time there's a major federal action that has a significant impact on the quality of the human environment, an environmental impact statement should be prepared that disclose the consequences and the alternatives to those actions. The Endangered Species Act, which is always the subject of dispute, protects species. It's a biocentric statute that speaks to protecting species from becoming extinct. And another example is the National Park Service, created by Congress to protect and manage national parks. At the state level, there's a whole pattern of laws, again, dealing with allocation of natural resource, protection of human health, protection of the resource, dispute resolution. So examples in Texas, surface water is owned by the state of Texas, and it's allocated and managed by the Texas Commission on Environmental Quality, and they have to follow the Texas Water Code, which has been enacted by the legislature, that speaks to ownership and allocation of the rights to use surface water. In the state of Michigan, the state has enacted an Environmental Protection Act that allows citizens to bring actions against the state or private parties to protect the environment. Another example, in New Mexico, the Solar Rights Act grants to landowners the right to erect solar panels to generate electricity, even if it has an impact and cast shade on adjoining properties. At the local level, in terms of federal, state, and local ordinances, building codes, or landscape requirements have an impact and are important for the allocation and protection of natural resources. Administrative rules. Congress and state legislatures, when they enact laws, oftentimes do not take into account all the different variables that could be impacted. And so they grant to administrative agencies, the executive branch of government, the authority to adopt rules that define or interpret ambiguities in federal and state statutes. These administrative rules have the full force and effect of law. So if you violate an administrative rule of an agency at the federal or state level, you could be subject to a civil as well as a criminal penalty. You could be subject to jail time for violating an administrative rule. So an example currently under extensive discussion is the waters of the United States, this WOTUS rule defining how EPA and the Corps of Engineers will define federal waters for purposes of the Clean Water Act. So it's subject to extensive discussion and debate. The National Park Service has administrative rules that deal with conduct within national parks. The same is true in national wildlife refuges or any other federal enclaves. At a state level, there are administrative rules for example, in Texas, on hunting regulations. And at the local level, again, dealing with building codes or landscape requirements. Another source is judicial sources. And when we talk about this, people oftentimes have certain ambiguities on the role of courts. So the courts have a number of functions. Two major include to resolve questions of fact. Did something occur or did it not occur? Was an administrative rule or a federal or state statute? Was it exceeded if there was a pollution discharge? So courts determine these as questions of fact. They also determine and interpret federal and state law. So that's part of the jurisdiction. People will argue, well, we don't want our courts to make law. Well, in effect, they make law when they interpret provisions in a federal or state statute, or they define the extent of coverage in that statute. Federal courts have limited jurisdiction. So in our system of government, our courts are really federal and state courts. Federal courts, limited jurisdiction, they have to raise a constitutional question. So if a statute deals with a treaty, a boundary dispute, or state-to-state disputes over natural resources, those questions are resolved or attempted to be resolved in federal court. Second provision, when there's diversity of citizenship, when a citizen of one state sues a citizen or a corporation of another state over contamination of water, pollution of air, whatever it may be, those disputes then are settled at the federal court level. All other disputes really fall within their jurisdiction of state courts. So federal courts deal with federal questions of constitution or statute or administrative rules or differences between the parties, between citizens of different states. Natural resource disputes are then of a local or state nature are settled in state courts. Let me move away from a discussion of sources of law and impacts and talk about patterns of natural resource and environmental rules. If you think about the whole range of federal and state laws, you can look at them in a number of categories. One set of statutes deals with and is involved with only disclosure and notification. So the National Environmental Policy Act is an example. When you look at a pesticide or an herbicide or a product to eradicate bugs, you will see warning labels on the backs of those packages on how to use and apply the pesticide, the herbicide, the rodenticide, how it should be applied, when it should be applied, what should be avoided. All of those are disclosure requirements that don't seek to prevent the use of that product, but merely to disclose the risk and consequences. A second category or pattern of law are the so-called command and control laws. So most of our pollution legislation falls within command and control, where limits are established, compliance is required, and there are penalties for non-compliance. A third pattern are activity controls, such as where facilities are located. So if it's a nuclear power plant or a disposal site for toxic, hazardous, or just plain solid waste, there's a pattern of laws that speak to siting where those facilities have to be located. Activity controls deal with regulation of parks, wildlife refuges, wilderness areas, or species protection. Another pattern of laws deal with transportation controls, signage, routes, or containers. So I often tell people, if you travel throughout Texas or many other states, as you enter a town, you will see a classic example of a transportation control. It's called the truck route. So semi-trucks, large vehicles are prohibited or restricted from going on local streets. They're generally moved around on a traffic control street so they avoid downtown areas where an accident may have consequences, or the load of the vehicle is so great that it exceeds the load carrying capacity of the street. Also dealing with containers. Another pattern that we see particularly after hurricanes, environmental events, is response and remediation. So site cleanup, disaster response under the Federal Emergency Management Act, and compensation. So victims that were subject to the Hurricane Katrina, Hurricane Harvey, major environmental consequences will receive a level of compensation and remediation from the federal government. So when we think about natural resource laws, we just want to recap, think about the functions of law: to allocate resources, to protect human health, to protect resource protection, to resolve disputes, to deal with environmental justice. All of these are functions of the law in natural resource management. Sources of law, remember, at the federal and state level, federal constitutional provisions, statutory provisions, the same at a state and local level, and the different patterns of laws. This concludes the discussion in the module on natural resource and environmental resource laws.